In Chillicothe, Missouri, three OSHA inspectors, two compliance officers, and an area director were driving past the municipal airport. They noticed a construction crew erecting a new hangar. They believed that they had witnessed possible fall protection violations. Applying OSHA's plain view doctrine, the compliance officers pulled over and conducted an inspection. When the compliance officers spoke with the workers on site, the workers, every one of them, stated that they were independent contractors. When asked who the employer was, they stated that they didn't have an employer and that they worked independently. Shortly after the officers arrived at the site, all of the workers packed their belongings into a van and left the work site. Left only with scant evidence, OSHA issued citations, some serious, some repeat, against the project owner, JTM Services. JTM Services argued, by contesting the citation, they argued that they were not the employer for those workers. I'm Manesh Rath. Today, we'll discuss the judge's analysis and what lessons can be applied from this case in light of the decision issued by the administrative law judge on this, the June 2025 episode of the OSHA 3030. Well, welcome everyone to the OSHA 3030, a 30-day program, which in 30 minutes we try and cover a new area of OSHA law. And as I said before, I'm Manesh Rath. I'm a partner at the law firm Keller and Heckman in Washington, D.C. And for 30 years, I've been engaged in management side representation in the field of occupational safety and health law. I'm joined today by my colleague and friend, Ben Idzik. Ben, welcome to the OSHA 3030.
Manish, always great to be here.
Well, it's great to have you here. Ben, we've got a great subject, the JTM Services case. Why don't we go ahead and start by working through what it is we're going to talk about today?
Right, let's do it. So we'll begin, as always, with the facts of the case. Then we'll discuss how OSHA is to establish a citation. And then we'll go through a particularly relevant test to this case known as the Darden test.
So, test in the field of employment law that the judge applied here in the field of OSHA law.
Exactly. And then after going through the test, we'll cover the ALJ's decision, his reasoning as to how he came out in this case. And then, as always, we'll conclude with practical tips for the OSHA 3030 community that can take away from this.
This is pre-recorded, so we won't have our final section that's off the record. But if you all have any questions about this subject matter or any black letter law question of law relating to OSHA, why don't you just go ahead and send us an email in the intervening 30 days, and we will address that in a post-program section in the July episode. And if you all want to see the live program come back, shoot us an email and let us know that you'd like to see the off-the-record section come back and for us to do the program live for that purpose. So with that said, why don't we get into the facts of the case? So this starts in Chillicothe, Missouri, a small town northeast of Kansas City, Missouri, where at the municipal airport, there was a construction project involving the erection of a hangar. And the general contractor was Generational Buildings, a general contractor in Missouri owned by two brothers. I think Johnny Troyer was one of the two brothers who owned Generational Buildings.
Yep, he sure did. Johnny owned the Generational Buildings, and he also owned a separate entity known as JMT Services. And in this case, what JMT did is it functioned as a subcontractor for the project. So when Generational Buildings was awarded the contract for the airplane hangar, it awarded the part of constructing the roof and the frame of the hangar to JMT Services.
Right. And to be clear, Johnny Troyer owned 100% of GMT Services, but was a part owner along with his brother in the general contractor Generational Buildings. So this is a framing and hangar erection company. They've been engaged at the airport. What Johnny Troyer states in his testimony is that his role, or JMT Services' role in the project, is that they get awarded a subcontract from Generational Buildings, and they do a site check, and then they create a design or pull blueprints for the job, and then they hire workers to perform the work.
That's exactly right. And there was some discussion in this case about sort of the history of how JMT operated. Initially, it had a traditional relationship with its workers, an employee-employer relationship. And then sometime in 2022, I believe it was, the owner, Mr. Troyer, transitioned over to a independent contractor model. And that posed some interesting things with how this case came up.
Yeah, Mr. Schroyer stated that he made that change strictly because employees preferred to be independent contractors, and he was merely making this transition from directly hiring them as employees to separating them from employment and re-engaging them as independent contractors in order to address their request.
Mhm.
They brought to the table a lot of their own expenses and didn't believe that the employee model was the right taxation model,
Mhm.
where if they could declare their own taxes, they could address some of these business-related expenses more effectively. That was his testimony as to the reasoning for transitioning to an entirely independent contractor model effective sometime in 2022.
Right.
Interesting change. So what he says is, at this stage that I use independent contractors, all I do is I do a job site uh, check in, observe and inspect the site, and then I provide the blueprints and some of the job equipment, the compressor. Workers bring their own pneumatic tools, but I'm happy to supply a compressor. And I have a few off-road capable forklifts that they can use if they want to. They don't have to.
Mhm.
I believe he said I have a van that they can use for getting around just so that they can keep their own vehicles, their own personal vehicles clean. And then a little bit of personal protective equipment, if I'm not mistaken.
Yeah, they provided, like you mentioned, some equipment. And I think the interesting part of how this relationship governed was that Mr. Troyer, when he went about staffing a project, he would go through a process of identifying workers from his network, also prior employees of JTM services, and then you have them execute a written agreement, which clearly stated that he was operating under independent contractor model. So under this agreement, the workers were paid on a commission basis, so based upon the total labor charge that JTM would receive from the general contractor. And they were not provided with any sort of insurance, retirement funds. They were paid by check without tax withholdings. So the model very much functioned like an independent contractor model, it seems from just off the top.
That's right. And the idea that they all brought their own tools and that they were bringing their own vehicles, but leaving it there and using some equipment like the compressors
Mhm.
and the forklifts was an issue that the judge spent a lot of his opinion analyzing. But I think that you've put your thumb, Ben, on the real interesting point, which is what JMT testified to through Troyer was that all they did was they provided the blueprints, they found these workers, and then they told them, here's the blueprints, here's what the end result needs to look like. Go ahead and get it done.
Mhm.
He didn't tell them how to do it, when to do it, what order to do things. He didn't supervise them on a day-to-day basis.
Right.
Once they began their work, he never visited the site, or he at best occasionally visited the site, but he really was hands off.
Mhm.
There was no supervisor. All of the workers on the site were independent contractors reporting directly to JMT. Not one of them was hired as his foreman or supervisor of the others. There was one worker named Mr. Yoder, who was more senior, and he had been on a lot of jobs for JMT, and he would report into Mr. Troyer, oh yeah, this worker's showing up late or not showing up on time or not showing up at all. Another worker's doing good work is showing up all the time. Mr. Troyer testified that educated him as to how to hire people for subsequent jobs. But implicit in that testimony, Ben, I think he's also saying that he didn't remove them from the job for that particular job site. He would wait until the next job when came up, and then he put the word out to decide whether or not this worker who had maybe gotten a negative review from Mr. Yoder would be included in the invitation for the next job.
Mhm.
But on this particular job that the worker wasn't working out on, Mr. Troy did not testify that he would, on the basis of Mr. Yoder's reports, would yank anyone off the job site or terminate their engagement.
Yeah, it seemed like a very sort of informal relationship, and I think what's interesting with Mr. Yoder is that he was one of the a long-time associate of Mr. Troyer, and also previously an employee there, like you mentioned, had a lot of experience. So it seems like certainly when the ALJ's in the ALJ in the ALJ's eyes, that Mr. Yoder was just more of a trusted advisor in how to go about hiring future folks for projects, as opposed to being a foreman, like you said.
Right. He was just one of many independent contractors, but the one that Mr. Troyer described as his go-to
Right.
guy.
Exactly.
And that happens. But when Mr. Troyer testified to as to subsequent jobs, as jobs kept coming up, he would put the word out and invite workers to accept the engagement, and that they were free to say no.
Hmm.
If they wanted to, they could turn down the job, and they frequently did.
Right.
And I think that that is maybe one of the most uh, instrumental facts, is that people were free to accept a job, they were free to turn down a job. Some of them did always accept a job, and some of them, in their turn, would work for him for a little while and pick up other jobs
Hmm.
with other employers. Uh, and that none of them ever testified that they were directly supervised by Mr. Troyer or by
Exactly.
Mr. Yoder.
Yeah. And to that end, too, they also had other jobs. Some of them had other jobs while they were working on this project in particular.
Right. Here's one other interesting fact, Ben. The way they were paid. They didn't get paid by the hour, and they didn't even get a flat fee for the job. They got a percentage of the labor portion of the contract. So generational buildings would assign to JMT Services a fee for the framing and roofing job, and some of that would be allocated to parts, materials. Some of it would be allocated to hiring labor, and some of it might have been allocated to overhead and profit. And that labor portion, Mr. Troyer would assign a percentage of it to every
Mhm.
worker who was on the job.
Mhm.
That to me does not look like an employee. I don't think that that is a typical way for employees to get paid. The typical way is either an employee is paid by the hour, or by a salary, or by production volume.
Mhm.
That is to say, production volume would be, for example, a piece rate.
Right.
Those are, or commission, sales commissions. Those are examples of how employees are typically paid.
Mhm.
So that's one more interesting fact. Okay, so we talked about the inspectors. These two inspectors, along with their area director, happen to be driving by. We should discuss the plain view doctrine for a moment. This is an interpretive policy position of the Occupational Safety and Health Administration. Their belief is one that goes to the greater subject matter of probable cause, that OSHA can conduct an inspection on site because it's empowered to do so by Congress. But there's still the background construct of probable cause. So if it is a inspection that's based on a complaint or a referral, there's probable cause to believe that the underlying substance of the complaint or referral form the probable cause to conduct an inspection. And then there's several other forms of inspection, and this one is the plain view doctrine, that if something is visible in plain view while they're driving by in public spaces, and they can see what they believe to be a possible violation, that gives them the probable cause to enter and conduct an inspection. And that's what happened here. It is a doctrine of enforcement for which construction is particularly vulnerable,
Sure.
because it's just out in the open,
Mhm.
and any driver by can observe the activities of construction workers. So construction industry contractors and subcontractors are particularly vulnerable to this doctrine. But I'll say that even, for example, in manufacturing, we do a lot of work in construction, but we also do a lot of work for manufacturers. If OSHA was, and a compliance officer was to come in and conduct an inspection for a complaint about a particular machine, and then they see in their pathway to that machine some other alleged violation, that would be sufficient probable cause under the plain view doctrine
Right.
to expand their inspection right then and there. So here we have construction. So they're driving by the highway, and they notice what they had believed to be a possible fall protection violation, and they conduct this inspection. Uh, what they saw when they got there was workers who all claimed that they didn't work for any employer. There wasn't a single employer representative on site. And when the workers packed up their things, got in the van, and left, and ended the job for the day, the compliance officers had nothing left to do but take measurements, some photographs, and then decide whether to issue citations. They did issue
Right.
citations. several, and some of them were repeats, some of them were serious citations.
Yeah, I think what's interesting in the facts of the case, how, and I think you previously alluded to this, how when the compliance officers confronted the workers, particularly Mr. Yoder, Mr. Yoder, like you said, identified as an independent contractor and then left. So it kind of left OSHA in a position to have to go do the digging and figure out, okay, it turns out that JTM hired these
Right.
guys, and they conducted background and saw that JTM prior to being under this independent contractor model, receive similar citations. So that probably also, encouraged them to maybe go back and issue these citations again.
Yeah, and it's the basis for the repeat as well. So
Right.
JMT Services argues that they can't be liable for these citations because they're not the employer.
Mm.
That only an employer is liable for violations of an OSHA standard, and that these workers were not employed by JMT, nor were they employed by anybody for that matter. Their
Yeah,
violations, therefore, are their own.
exactly.
Uh, at this juncture, I should point out, I think it's helpful to discuss a couple of areas of law that come into play. One of them is, well, whether or not an employer is the statutory employer in fact. There is an argument that can be made in the greater field of workplace law that maybe an entity is nevertheless an employer as a construct of law. And this comes up, for example, in the field of wage hour law, where an employer will say, well, I only want to hire a worker as an independent contractor. And then that independent contractor ends up working, let's say, 50 hours in a week. And if the Department of Labor gets to hear about this, or if the employee decides that they want to press their rights under the Fair Labor Standards Act, or assert that they have rights under the Fair Labor Standards Act, then the first threshold question for the court would be whether or not, despite the fact that the independent contractor was not an employee in statutory law, whether or not they were a de facto employee of the possible employer. And that argument, or that inquiry, or that analysis is settled by looking at a lot of features of the relationship. In other words, the court is going to say it doesn't matter what the parties said that their relationship was, whether they agreed that it was a employment relationship or an independent contractor relationship. We will look at what it was as a matter of reality, how they actually behaved in everyday transactions. So one case, Nationwide Mutual Insurance versus Darden, a 1992 case that went all the way up to the Supreme Court, has been considered a headwater case for establishing some of the features that courts should look at when considering
Right.
whether or not we're looking at an employee.
Yeah, exactly. And the test outlines several factors, many factors that the court encourages other courts, lower courts, and in this case, the ALJs at OSHA to look at to determine whether, in fact, like you mentioned, the hiring party is an employee or just somebody that's hiring an independent contractor. And I believe, Manish, you were involved in a case in the 11th Circuit that argued along these lines.
Yeah, that's right. That became, I think, the headwater case for the 11th Circuit on the factors being applied to co-employment. And here, this would be a question of whether these nominally independent contractors were de facto employees of JMT. I think the factors that go into co-employment or actual employment or de facto employment are very similar. They overlap with each other. Let's talk about some of them.
Yeah.
I think the first one, and maybe the most important, is how much control the engaging party has over the worker on the day-to-day supervision of how the work is performed.
Exactly. And I think that is sort of the thrust of the whole test is, like you mentioned, determining how much control the hiring party has. And the court in Darden and these other cases it directs us to see that the more control the hiring party has, the more the relationship suggests an employment
Right.
relationship.
And the first test is the employer's uh, whether or not there were facts suggesting that the employer engaged in day-to-day supervision
Right.
to direct the work of the employee. Other things that they look at, I think, are certainly important, but not as probative as that. That singular question of the day-to-day direction and supervision of work is the singular most influential, but they all are taken into account by a court. For example, the skills of the hired party, whether they're skilled workers or unskilled workers, whether the hired party brings their own tools or materials to the job. And I'll say that last one, when I talk to employers, that seems to be outsized in their analyses of whether or not they're on solid footing for properly designating a worker as an independent contractor, is whether the worker brings their own tools to the job. And I don't see that being the case in court analyses in all the decisions I've read or argued myself in front of courts. I think that it's really the day-to-day supervision. There's one or two more that are even more powerful than that. But the who brings their tools to the job seems to get a great deal of emphasis by employers I speak with, and not as much by the courts or by me for that matter. So let's keep going. Let's talk about some of the others.
Yeah, we also have the control that the hiring party has over the worksite location, in terms of, like, again, the more control that you have over that, the more it suggests an employment relationship, the less an independent contractor relationship. We can also, the court discusses the duration of the relationship.
Yeah, that's the Microsoft case that came out 20 years ago. The longer the relationship, the more it looks like you're using an independent contractor relationship to get around as an end run around actual employment. And courts are more likely to find that this was all along an actual employment relationship. That case went to benefits, stock ownership benefits, employee stock ownership benefits packages that were handed to employees and not independent contractors.
And in this case, I think it was particularly interesting given how there was a period of time in JMT where the employees were, in fact, employees and then later transitioned to independent contractors. There was a long period of relationships, like with Mr. Yoder, that the ALJ definitely took note in.
Other things the courts look at: the employer's right to assign additional projects to a worker, and in that case, in the JMT case, they all testified that they had the right to decline work. The method of payment, we talked about that. In this case, they were getting a percentage of the labor portion of the payment from the general contractor to JMT Services, and whether the work assigned to the hiring party is a part of the hiring party's regular business. So if you have an accounting firm, for example, and they hire a worker who is an accountant, that is a fact that the court will say makes it look more like that worker should have been treated like an employee. But if the accounting firm hires, for example, janitorial services or landscaping on the outside of the building, the court would say, well, that's not what the accounting firm does. And so it's more likely that that worker was actually properly categorized as an independent contractor. So they want to look at what the model of the business is and whether the worker was fulfilling some portion of the business model of the engaging entity. All of these are, to varying degrees, influential in the judge's analysis. The court is supposed to look at these in the aggregate, holistically. To me, and as I've argued to courts, the most telling is the power to direct day-to-day work, the power to decline work, as was the case with JMT, the power to hire and fire. Mr. Yoder, OSHA wanted to assert to the judge that Mr. Yoder was a supervisor in fact, but the power to hire and fire is, without that, you don't really have a true employment relationship. And even Mr. Troyer never fired employees on a particular job site, despite the fact that he was hearing that they weren't working out well. He may have not re-engaged them on another job, but he never terminated them. When the job was done, they were separated. And as to whether they would ever work with him again, that would require re-engagement. But Mr. Yoder, his go-to guy, didn't have the power to terminate anyone on the spot. And that also suggests that Yoder wasn't Mr. Troyer's supervisor on site or foreman on site, and that even directly or indirectly, Mr. Troyer was not exercising any control over these workers of the kind that I think is the sine qua non, this power to hire and fire, and secondarily, the power to daily direct work. You just don't see when you examine the facts on site at the Chillicothe Municipal Airport.
Right. Yeah, I think it all plays into this idea that Mr. Yoder was just a trusted, longtime associate that Mr. Troyer relied on for his advice.
Right, and that nobody had those kinds of powers over these independent contractors, workers, that nobody exercised the power to fire or hire or tell them how to do their work. Okay, so let's talk about the ALJ's decision. The ALJ looks at all the factors that you and I just discussed and starts to examine one by one which ones he thinks are more or less influential.
Right. And like you mentioned, Manish, he pays particular attention to the control aspect, and he discusses how JMT had no day-to-day involvement in the actual project, the airport project. Mr. Troyer came out to the work site to conduct initial assessment, and then he selected the workers who chose to join the project. But after that point, he provided the blueprints, and then it was hands off. He didn't come and set work hours. He didn't come and assign particular workers to particular tasks. Rather, he relied on these folks who in the record were indicated to be experienced roofers, experienced framers, and he relied on them to set their own conditions.
Yeah. OSHA asked, how is this possible that all you do is give them blueprints and then they just go do it? Mr. Yoder stated, this go-to guy for Mr. Troyer stated, well, it's essentially a pole barn and we've done so many of them.
Mhm.
We know how to build a pole barn. We don't need anyone telling us how to do it. We just need to see the blueprints for this particular pole barn and then we go to work. And that's basically what they were doing. The administrative law judge looked at all of these factors. I think that one of the things he looked at as being most compelling was this idea that the workers could decline assignments. But all the other factors, one by one, he said most of them looked like facts that lent him to believe that this was an independent contractor relationship.
Yeah, like in terms of the tools that we discussed earlier, the ALJ noted how the workers brought their own nail guns, their own nails. The only thing that JMT supplied was an air compressor, which was essential to the project, but the ALJ sort of in the aggregate viewed that as not outweighing the other factors.
Right, and some off-road forklifts that were not essential to the job. They made the job a little easier, but they weren't necessary for performing the work. Ultimately, the administrative law judge concluded that this looked like an independent contractor relationship. Ben, I suppose at this point we should talk about the multi-employer worksite doctrine. It's impossible to understand this analysis without asking yourself, well, why then isn't JMT liable under, if JMT was not the direct employer of these workers, why are they nevertheless not liable as the controlling employer? But all four types of employer that are found in OSHA's interpretive multi-employer worksite doctrine are nevertheless employers
Hmm.
of some sort or another. And the controlling employer, as one example, which I think that would be the one you'd most commonly think of in this fact pattern, the allegation would be, well, you may not have been the employer of these workers, but you, JMT Services, should have had enough facts as to what hazards might exist to at least inform or take some reasonable measures of abatement the employer of these workers so that there could have been a change in practice or conditions so that the workers would have been performing the work more safely. The problem with that in this particular case is there was no other employer of these workers.
Mm.
These workers were truly independent contractors. And so theoretically, the only place left for the compliance officer to consider issuing a citation against would have been each of these individual workers, the way you might theoretically issue a citation against an employee for failure to comply with the standard. But I'm not aware of any such case ever where OSHA has ever issued a citation against a worker. And so that would explain the reluctance to do so here. The controlling employer doctrine would not have applied since there was no other employer of these workers to make the allegation that JMT as a controlling worker should have taken some interdictive or abatement measures with respect to the actual employer. So then it only comes down to the question of whether or not JMT was a de facto employer. And as we talked about, the judge believed that that was not the case, that this was a true arm's length independent contractor relationship. Well, what do we think employers should do in light of the JMT case? Because I must say, I don't recollect the last time I saw a decision on this subject matter at the Occupational Safety and Health Review Commission, where an employer was able to successfully contest a citation on the basis that the workers were truly independent, not only of the cited employer, but of any entity. So let's talk about what we think employers should do in light of this.
Yeah, I think the first thing is to make sure that the relationship between you as the members of the OSHA 30 community and any independent contractors that you hire is clearly defined as such. And what's interesting in this case is that we saw the agreement that stated that this is an independent contractor relationship, but still this came up before the ALJ. Ultimately, the ALJ agreed that this was an independent contractor, but
Yeah.
even an express agreement may not be enough.
No, that's right, because the whole point of the allegation that that was the relationship in fact, but there may have been a de facto employment relationship, is premised on the idea that the alleging party is going to ignore what's written in the agreement
Mhm.
and look at the actual facts of a relationship. So, yeah, I think you're right, Ben. Employers need to not only clearly define the relationship in the agreement, but on a living relationship basis every day needs to behave in a truly conforming manner to the idea that this is an arm's length independent contractor, that you can't direct them on a daily basis, you can't fire them, you can't exercise the kind of powers that an employer would exercise.
Mhm.
I think the next thing that employers can take away from this case, this decision, is prior to engaging a worker or an independent contractor that's incorporated, that it's, I think, important for employers to examine that contractor's existing safety and health plan or their safety and health practices as part of the selection criteria. If it's an individual, ask them how they would perform the job safely before engaging them. If it's an entity, ask to see their written safety and health plan. If it's a vendor or a supplier, take a look at their safety and health program, have them supply it as part of their response to an RFP. I think this is critical. We advise clients to do this all the time, and we review the responses to RFPs with clients that are particularly proactive in managing the relationship with outside suppliers, vendors, contractors, subcontractors.
And I think related to that point is to also make sure that you scrutinize the records of these individuals. You don't want to hire a troublemaker and then end up having to deal with a situation like this in this particular case. So it's important to go through to hire to utilize counsel or some other professionals to go through the records of independent contractors to make sure that you are joining together with the responsible party.
Yeah, I think that's right, Ben. I think it's reasonable, and we see it with our construction clients and with other clients in manufacturing, et cetera, that they, in the RFP process, they ask parties submitting bids to provide documentation as to prior OSHA violations, state plan state violations, workers' comp records, et cetera, to get a sense of the safety track record for these potential vendors, suppliers, or independent contractors. We've pulled a little bit of track switching here, however, just to point out for our OSHA 3030 members to incorporated entities that are contracting, subcontracting, as opposed to individuals, as we saw in JMT Services case.
Right. I think the final point to consider here is when hiring an independent contractor or subcontracting to an independent contractor, consider requiring them to have a safety supervisor on site as part of their operation so that there's additional assurance that these folks will indeed abide by the safety regulations.
Right. And I note that that would be an extra cost that the contractor will obviously end up having to pay out through the subcontract itself. But if you're engaging a team and it's a safety intensive job, I think you're right, Ben, that it would be reasonable for the subcontractor to supply not only the team, but a safety supervisor or a supervisor who's capable and qualified to monitor for safety compliance as part of that team. And that maybe should be priced in to the engagement. I think that that's a reasonable thing to expect. There is another case coming down the pike uh, that's gone all the way up to the 11th Circuit that goes to specifically that question. And the employer argued that it would be economically unfeasible to do so and made a compelling case. When that case comes out, I can assure you that's going to be a topic of one of our immediately forthcoming episodes of the OSHA 3030, because I think that that subject, along with this one, is of such importance to so many employers, because almost every employer engages either independent contractor, individuals, or entities, plus suppliers and vendors, et cetera, so that these questions become sort of universally important in the field of OSHA law. All right, well, that's today's OSHA 3030. Thank you all for joining. Our next episode will be 1 p.m. Eastern on July 16th, 2025. We look forward to seeing you then. In the meantime, if you have any questions about this case or any other aspect of OSHA law, feel free to reach out to us, Ben or me, by calling or emailing us, texting us. Many of you have our mobile numbers. and we're happy to chat about it. We're OSHA nerds. We love chatting about this stuff anytime, and we love staying in touch with you as well. So please reach out with any questions you might have. Don't forget our sister programs, the Reach 3030 and Tosca 3030. Tosca 3030 on August 13th, 2025 at 1 p.m. and the Reach 3030 August 27th at 10 a.m. Eastern Time, U.S. Those programs are fantastic. Pass the good word on. Please also, when you get the invitation for the next OSHA 3030, continue to do the great job you've been doing of forwarding it on within your organization and at other organizations to at least 3 other people every time. Consider that the fee for your free registration for this program. We are thankful to you for being a part of this program for the past over 12 years that we've been doing this every single month. And all we ask is that you continue to forward it on. So thank you all for participating in this edition of the OSHA 3030. I also want to thank the staff here at Keller and Heckman for producing the show and my friend Ben Idzik for being on the show with me. I'm Manesh Rath. And on behalf of Ben Idzik and myself, thank you. And we look forward to seeing you again next month. And until then, stay safe.